All right, why don't we go ahead and bring in national trial attorney Michael Jaafar, who is here with us now to discuss. Michael, I believe we got those technical difficulties worked out. Nice to see you, Michael, as we watch this case out of Boston, and Judge Ashley and I have talked about it. It is so fascinating, this case. It's a retrial for him. Give me your thoughts. We're just listening to someone on the stand now just talking about, this is a rape case, and she's providing some testimony now. What are you taking away?
What I'm taking away is this is a very winnable case for the defense attorney. If the defense attorney performs on even half of the promises he made in his opening statement, he should get an acquittal. I'm thinking of two rape defendants I represented with identical facts, minus the whole Irish fleeing the country thing, and I got an acquittal for both defendants, right? And I was a young attorney. This is a very winnable case. The burden of proof of beyond a reasonable doubt is a very, very high burden. It's the highest burden in the land. And so with no DNA evidence and with the corroborating evidence of her being in that room, not being accosted and brought into that room, there's so much reasonable doubt. Did he probably do it? Maybe. Women usually will not lie about something like that. So my hunch tells me he did it. But whether or not he's guilty beyond a reasonable doubt, that is a very high burden. I'm curious as to why it was a hung jury in the first trial, but this is a very winnable case. The defense attorney is an average order. He could have done a much better job in the opening statement, but he linked the events in a way that, for me, I said, if he can prove half, if he can deliver on half of those promises, it should be an acquittal.
So I think the reason it may have been a mistrial was some of what you said, in addition to the victim testifying. I think the jury must have believed her, some of the jury, and that's why there's a mistrial. But I want to hone in, and I'd asked Kelly about this when we lost you with technicalities earlier, because the thing that I think really makes a difference in this case is if it's true, which we expect it to be, the defense said in opening, that the victim has never identified the defendant. I think that's a significant reason why there may be a mistrial the first time, or why you may suggest there might be an acquittal.
I fully agree with your analysis on that. 1,000% agree with your analysis on that. That, on top of the fact that there's no forensic evidence that he interacted with her, all of that is why, in my opinion, it's no question an acquittal. Again, a woman isn't going to lie about something like that. What bothers a defense attorney is when the prosecutor can get into evidence the fact that there's so much shame that comes to a woman, unfortunately, when she brings something like this to light, and she's vilified by even people close to her. And so that is sad, and that is something that hurts the defense's position if the jury hears that, which is why I think probably he did this, right? Why would she complain? Has somebody complained about rape before and lied? Yes, it has happened before. Is it the majority of the time? No, it's not the majority of the time. So I think he probably did this, but whether or not the prosecution can prove it beyond a reasonable doubt, I think it's tough.
Yeah, it's a tough case, and the victim having to testify again is traumatic to her based on those allegations. Michael Jaafar, thank you so much for joining us tonight, as always.